Okay, good morning, everybody. Thank you for joining us today on this wonderful Wednesday morning. We're just gonna, wait a little bit while everybody starts getting, coming into everything. So this morning's webinar is on the COVID-19 stimulus bill that was passed a little while back, and just a lot of getting everything, kind of returning back to normal as much as we can. Today we do have our Stacy Barrow. He is Martha's Barrow Weatherland Lent LLP. He has done a wonderful job for us in the past, and he's a very prestigious speaker on these topics, and we are very lucky to have him today, and that he was able to make some time for us rather this morning out of his very busy schedule. So with that very brief introduction, I'd like to hand over the webinar over to Stacy, and we'll be get everything going.
Awesome, thanks, John, and good morning, everybody. It's Stacy Barrow from Martha's Barrow Weatherhead Lent, and we are proud to partner with SterlingRisk to offer today's webinar. Let's have a few more people coming in here. So we have a few things to cover today, one of which I forgot to remove from the agenda, which we're not going to cover, is the last item because these rules have been withdrawn. But we are going to focus on the second stimulus bill and the COVID-19 relief, some of the disaster relief from last year. If and when that's ending, it should kind of be coming to an end at the end of February. We'll talk about some of the vaccine considerations and incentivizing versus mandating versus encouraging, what might be next for healthcare under the Biden administration. And then I was going to cover the proposed rules on wellness programs, but they were officially withdrawn by the Biden administration as part of a review. They basically pulled all proposed regulations that hadn't yet been published in the Federal Register, and those were they were proposed. They hadn't quite hit the Federal Register yet, and so they are withdrawn. Maybe they'll be promulgated again in the near future, but until then, we're not going to waste a lot of time on them. So wanted to start this morning with the second stimulus package, the one that was passed at the end of 2020, signed into law by President Trump. This was a huge stimulus bill. It was a kind of a culmination of several acts, including a spending bill. It was something on the order of 5,900 pages, and contained a number of provisions that are relevant to group health plans. In a way, it's almost like this was a mini Affordable Care Act with all the patient protections. And even if we didn't have the new Biden administration, just the changes in this act alone would keep us busy from a healthcare perspective for the near future. So I'm going to focus on this for the most part today, and then we'll also kind of keep an eye on what we think the new administration will do. So a couple of the highlights of the second stimulus package. One of them was the extension of the FFCRA leave, the emergency paid sick leave, and the expanded FMLA provisions of the FFCRA. Those are voluntarily extended for employers through March 31st, meaning as an employer, if you want to continue allowing employees to take that emergency paid sick leave, you can continue to get the corresponding payroll or the tax credits. So it would still be cost neutral to the employer. You get a tax credit for both the wages and the healthcare expenses for employees that use that leave, and that's generally available to employers with less than 500 employees. There's also relief from the use it or lose it rule that typically applies to health FSAs, independent care FSAs. This is also voluntary for plans to adopt, but we're seeing a lot of employers adopt this relief for their health FSAs, independent care FSAs. We'll spend time on that as well. And then I'll also cover these new patient protections. There were some entire laws actually that were part of the Consolidated Appropriations Act. And one of them was the No Surprises Act that kind of purports to end surprise billing in certain situations. So I think that'll be interesting to talk about. Most of these provisions are effective next year, and we'll see regulations during 2021 that'll help us implement these laws. So one of the pieces of relief under the stimulus bill dealt with FSAs, both health and dependent care FSAs. And it basically allows employers, either if you have a carryover or a grace period, kind of operates the same way. It allows you to either enable participants to carry over their full unused balances from 2021 or from 2021 to 2022, or you can extend the 12-month grace period for the plan years ending in 2020 or ending in 2021 to 12 months after the end of the plan year. In other words, they both operate the exact same, and it's to allow full use of any remaining funds at the end of these plan years, either carried over to the next plan year or the 2.5-month grace period is extended. We're seeing a lot of employers take up this permissive relief here. It's not mandatory, but many of the FSA vendors are enabling clients to take advantage of it. There was some guidance on it in the last week or so, a notice. We're still kind of working our way through it, and it expands upon and clarifies a lot of issues that are hanging over some of the, how to take advantage of some of this relief. So we're working on a client alert on that. We'll be releasing it to Sterling in the next few days, hopefully. That will fill in some of the blanks as it relates to how exactly this relief should work. Another piece of the relief, in addition to allowing employees to avoid forfeiting their balances at the end of the year, you can adjust your FSA, your health FSA, in a way that allows employees who terminate during the year to continue to access their balances that they've contributed, the amounts they contributed through the end of the plan year. So if you've elected $2,500 in your FSA, you've put in $1,000 and then you terminate employment or you lose eligibility for the FSA, you could allow the employee to continue to access that $1,000. Now, it doesn't take the place of offering COBRA. If it's a COBRA event, you would be able to elect COBRA, access the full $2,500 in our example. But this is something that you can, another piece of relief you can avail yourself of, although this one I think is maybe has some more limited usefulness than the first one, which is just allowing the full rollovers of the balances. Just like last year, you can allow employees to make changes to their FSA or dependent care elections without having to experience a change in status event. This is, of course, great relief. It applies to plan years ending in 2021. And there was some expansion of this in the latest IRS notice, allowing employees to make election changes for medical coverage, similar to how it was done in 2020. And then also providing some guidance on how employees can utilize these accounts, which I think is interesting. You can let employees change their elections, increase their election amounts, and have that amount available for the entire plan year. And again, we'll be expanding upon this in an alert. But typically, when you make an election change, if you're going to put, say, increase your FSA election, your health FSA election by $1,000, that $1,000 would be available for claims incurred after you make the election change. But this relief, because of COVID-19, the IRS is going to let that added dollar amount, that increased election, apply back to the start of the plan year. So I think that'll be pretty useful for employers to adopt. And we'll have more to you on that soon. There's also some relief as it relates to children who aged out of dependent care FSA eligibility during the pandemic. Typically, under a dependent care FSA, the children are no longer eligible once they reach age 13. And so if you're letting employees carry over their balances, say from 2020 to 2021 or 2021 and 2022, it's great. But if the children have aged out during the pandemic, then just allowing the carryover isn't going to be all that useful. And so this rule allows the dependent care FSA to continue to treat the child as eligible until they turn 14. This relief is somewhat limited. There are some nuances to it. Basically, it only applies to the balance at the end of the 2020 plan year. You can't make a new election in 2021 and use that balance for a child who's already age 13. So your vendors, I think, also will likely implement this one. I would think across the board for their clients, and they want to check with how vendors are implementing this. You have plenty of time to implement or formally adopt these changes into your FSAs or dependent care plans. You can amend your plans retroactively, to take advantage of the relief. You just need to adopt the relief by the last day of the year to begin after the amendment is effective. So basically, your calendar year 2021 plans need to be amended by the end of 2022. Your 2020 plans would need to be amended by the end of this year. And until you formally amend the plan, you just need to operate your plan consistently with how you're going to change it. So plenty of time there. There's been at least one IRS notice so far that will clarify how some of this works. There may be another one during the year as well, and there might very well be additional relief as the next stimulus bill begins to take shape. So one of the other provisions of the Continuing Appropriate or Consolidated Appropriations Act is the No Surprises Act, and this will be effective for plan years beginning in 2022, and it basically protects against surprise medical bills that arise in certain situations. This will apply to all plans, all health plans, whether it's individual or group health plans, self-insured, fully insured, large group, small group, level funded, minimum premium. It's going to apply to all of them. And it basically will operate in a way that allows participants to pay the in-network cost-sharing amounts for certain out-of-network services. For example, out-of-network emergency room care that will be charged at the in-network cost-sharing amount for a participant. Likewise, when a participant is at an an in-network facility, but they're getting services from an out-of-network provider, and we hear about this occurring for like anesthesiology services, where the anesthesiologist is out of network. In that case, the participant will only be responsible for the in-network cost-sharing amount. And then also, out-of-network care that's provided at an in-network facility without the participant's informed consent. That is also another situation where the participant will be responsible for the in-network cost-sharing amount, and the amounts that the participant pays will count toward the in-network deductibles and out-of-pocket limits. There are similar protections that apply for surprise air ambulance medical bills, and we'll get regulations on this during the year, but this is I think a pretty significant movement in more transparency and certainly kind of combating the surprise billing. So it also will probably add some cost to plans, self-insured plans as well. If the parties, the out-of-network provider and the plan, aren't able to reach a negotiated settlement, they can enter into an arbitration process. It's called independent dispute resolution, where one of the offers will prevail. They can batch claims when you're doing the same provider against the same TPA or carrier, and this process is supposed to be administered by independent, unbiased entities with no affiliations to providers or the big insurance companies. The dispute resolution process will consider a number of factors, such as the median in-network rate that the plan pays for the item or service, other factors like the provider's training and experience. This is something that out-of-network providers will often raise when trying to get a bill paid at a higher reimbursement rate. The acuity of the incident, was it an emergency? In some cases, the hospital itself, is it a teaching hospital? What kind of cases does it normally see? Were there any efforts in good faith by the providers to join the network in the past? All these kinds of factors will be considered when determining if the plan paid a reasonable rate. So it may not be so easy to just rely on, say we're going to pay 90% of Medicare for all out-of-network claims. There's a bit of a cooling off period that involves the parties not being able to take each other to dispute resolution for the same item or service within 90 days. As part of this, there'll be a lot more by way of disclosures. Plan ID cards will need to include the in-network and out-of-network deductibles, in the in-network and out-of-network out-of-pocket limits, and some other information like telephone numbers and website information. I'm not sure how big they envision these new cards to be, but we'll have to see. And then also, as part of the No Surprises Act, there's the concept of this advanced explanation of benefits, where if a participant files a treatment plan with the plan, treatment schedule, or is going to get a service and files that with the plan has between 1 and 3 days to turn around and provide what they're referring to as an advanced EOB that will disclose which providers are in network and which are not in network, the expected cost of the service, what the rate is that they usually pay in network, how to find in network providers if some of the providers are out of network, an estimate of where the participant is in their cost sharing, whether their out of pockets have been satisfied, where they are in their deductibles. So a lot of information here that'll be specific to the participant. It's like a summary of benefits and coverage, just a lot more individualized. There's also a provision of the law that bans what they call gag clauses in contracts between providers and health plans. And this sometimes prohibits employers from sharing their claims information in a way that would normally be permitted under HIPAA for plan operation purposes or administrative purposes, to market, to go out to bid and get kind of proper quotes from other carriers. So that's, I think, a win. We don't often see that in the Northeast and in the tri-state area too much. In other parts of the country, a lot of carriers sometimes use these. We see it in dental plans sometimes. So DOL Disaster Relief, you may remember this from in April of last year. The Department of Labor issued a notice suspending the time frame for plan participants to notify the plan of certain events like HIPAA special enrollment events, COBRA events, electing COBRA, paying for COBRA during what's referred to as the national emergency and the outbreak period. And this period began March 1st of 2020, and at that time was intended to run until 60 days after the end of the national emergency. And back when the guidance was released, the end date they had in mind was May 31st, I think, of 2020. That date has come and gone, and it looks like the national emergency will probably continue into the foreseeable future, at least for the next couple of months, say. And so the question that employers and plan sponsors have is, do we have to just continue this forever? At what point can we kind of draw an end here? And if someone tries to send in a COBRA notice that's a year and a half after the qualifying event date, will we be able to reject it? And the answer appears to be that all of the deadline extensions will come to a close after February 28th of 2021. And anyone who had a qualifying event, for example, during the outbreak period, meaning after March 1st of 2020, would then have whatever the regular deadline is for electing COBRA, 60 days, paying for COBRA, 30 days, notifying the plan of a special enrollment event, 30 days, and so on. There is some uncertainty, though, one, because the DOL and IRS haven't given guidance on it yet. So they haven't really spoken definitively on it. And the law, while it does, to me, read pretty clearly that the relief expires for everyone after February 28th, you could maybe read into it that the deadline suspension should actually apply on an individual basis. And if some individual had their event September 1st of 2020, they would have a year from September 1st of 2020 to make their claim, or to have that period extended. I don't think that's really a supportable read based on the law, but hopefully we'll get some guidance this week that that closes it out for employers. This is kind of an open issue for stop loss contracts. One point about this disaster relief: nothing in this disaster relief required employers to pay for COBRA coverage. We have had issues with carriers or COBRA vendors that have either neglected to terminate participants timely, or have encouraged employers not to terminate coverage. That's kind of unnecessary based on the wording of the relief and the regulations. If you think you've been in that situation, you should talk to your benefit consultant at Sterling, and they'll visit with you further on that issue. So moving on a bit to vaccine considerations, we've gotten a lot of questions from employers around the country with regard to the COVID-19 vaccine. Should we mandate it? Can we mandate it? Do we encourage it? Can we incentivize employees? How much can we incentivize employees? And there is a lot of uncertainty out there. I think we will get more guidance from the EEOC and GINA and OSHA, I should say, at some point in the near future. At the moment, it is kind of academic to talk about mandating the vaccines for most employers. They're currently available only under an EUA, an emergency use authorization. They're not fully 100% readily available to the public. And so being available only under an EUA kind of requires people to have the option of accepting or refusing it, which is inconsistent with an employer mandate. But once these get fully FDA approved and they're readily available and you can get it at the CVS, then in large part, employers will be able to mandate that employees receive the vaccine. There are, though, a number of considerations, and I will tell you that, at least in the employers I've spoken to, a lot of them that were initially considering whether or not to mandate have all moved to, we want to incentivize the employees, and what does that look like, rather than just a pure mandate. But again, once these become readily available, aside from the legal protections we'll talk about, you'll generally be able to impose this. You got to consider the business reasons for the mandate. Are you doing this because your employees are public facing, they're in close proximity to other employees or to customers? And then, of course, all the legal protections, like is what you're doing in terms of how you're administering your mandate, does that trigger ADA protections under GINA, Title VII as it relates to religious discrimination, and then similar state and local laws as well. I don't think it's going to be a problem in New York, but there are a few states out there, maybe 10 or so, that over the last year, we're looking at restricting the ability of employers to require the vaccine. And they were mostly in the red states, and I don't know if there's still a real appetite for that, but there are some movements out there that would kind of just require a closer look at what's going on at the state and local level. And then, of course, consider that your group health plan also will provide coverage of the vaccine once it receives an A or B recommendation. We'll talk about that in a second. So in terms of an employer that's decided they want to mandate the vaccine, and we do always recommend you talk to counsel before you do something like this, and we're happy to help as well. There's some EEOC guidance they issued in December, and it didn't break any new ground. It just kind of expanded upon their previous guidance. And they basically said the administration of the vaccine by itself, just getting the pinprick, the needle, by itself is not a medical examination. However, the pre-screening questions surrounding the vaccine would very likely be disability-related inquiries under the ADA, because it's going to involve questions about your medical history. Are you healthy enough to get the shot? So on. And so once you have these disability-related inquiries, now the mandate to receive the vaccine has to be job-related and consistent with business necessity. Now, you could kind of avoid this requirement and say, well, you just need to show us proof that you've received the vaccine from an outside provider that we as the employer don't contract with, like your own doctor, or get it at the pharmacy, and just show us proof that you've gotten it. The proof by itself is not a disability-related inquiry, as long as the form of proof you're providing doesn't include any other extraneous medical information. And then also, look, if the employee has a health condition or a sincerely held religious belief that precludes them from getting the vaccine, and they request an accommodation, like maybe they work from home or they're working away from others, the employer needs to then analyze those facts and circumstances and consider whether or not it's possible to make some kind of an accommodation for that employee without an undue hardship to the company. Ultimately, if you conclude, if your facts and circumstances warrant that having an unvaccinated employee in the workplace poses a direct threat that can't be reduced to an acceptable level by an accommodation, you could exclude that employee from the workplace. Doesn't mean that you can automatically terminate that employee, but it could potentially lead to that. As always, whenever you have an employee exercising these rights, you need to really consider the facts and circumstances, talk to counsel, and in most cases, unless you're in an industry like nursing home operator or some kind of medical industry where you really feel that you need to mandate it, you're probably going to get the most bang for your buck in simply encouraging employees to take the vaccine. I think there's probably a fair number of people out there who are not by any means anti-vax, but who are maybe a little reluctant to be among the first out there to receive it. So, definitely take into account your own employee base and then how all this would be perceived when mandating it or incentivizing it. The EEOC hasn't given a ton of advice or guidance yet on incentivizing it. Generally speaking, doing so through a wellness program that's part of your medical plan, an EAP, employee assistance program, or on-site clinic. These would all be, I think, viable pathways. They can raise ERISA issues when they're provided to all employees without regard to medical plan participation, depending on how you're designing it. We can help talk that through if you're interested in incentivizing employees. I think at the end of the day, there's probably little risk in a modest incentive for employees to go out and get the vaccine, but it does raise the question of whether you're sponsoring a group health plan. We often use the example of a flu shot program as something that that's certainly possible. The Department of Labor could consider that to be a group health plan. So I suspect we'll get some more guidance on this that will encourage employers to make it as easy as possible to get the vaccine. Once the vaccine is readily available and it receives an A or B recommendation from the U.S. Preventive Services Task Force, then all group health plans that are covered or that are subject to the ACA, like all non-grandfathered plans, will need to cover the vaccine with no cost sharing when it's received in network or out of network. At the moment, the out of network coverage rule is in place. It's temporary. It will apply through the end of the public health emergency, which is not the national emergency we talked about that's going to end on February 28th. That's something else. This is the public health emergency. This one gets extended every 90 days. And so it probably will get extended past April 21st. And so as long as this public health emergency is in effect, then once the vaccine is required to be covered by the group health plan, it'll need to be covered both in and out of network, no cost sharing for participants through the end of the public health emergency. These shots are not PS5s. Eventually, everyone will be able to get one. It'll be available at CVS, and you won't have to spend 5 hours on a website trying to get one of the first appointments. So moving on a little bit to what we think could happen under the Biden administration. One thing I would point to would be the ACA Enhancement Act. This was actually passed last year it was introduced last year in the House in August. It was about the time the ACA was being heard through oral arguments at the Supreme Court, and the Congress will sometimes do this to show what their position might be if there's a change in administration. And so last year in August, they introduced this legislation that, of course, was going nowhere, to kind of expand upon the ACA. And one of the things they've talked about for a couple of years now is tweaking the affordability subsidies to be a little more generous and cover more middle-class families. So this would reduce premiums for families that are eligible for marketplace plans. This is really intended to be for people that don't have an affordable offer under an employer-sponsored plan. I think this kind of change is something that can be done under reconciliation. You probably are more familiar with that term than you really care to be. It's the pathway for a bill to make its way into law with only by receiving a majority vote in the Senate, majority vote in the House, and a majority vote in the Senate. Normally, you need a 2/3 vote in the Senate, but when passing a bill through reconciliation, it can be passed just with essentially a tie vote, and then the vice president making the tie-breaking vote. So right now, at least until midterm elections, the Democrats, if they have a chance to do something through reconciliation, would be able to do that. And if there's the Byrd rule, which requires that it affects federal spending. And so there's only certain types of legislation that can be passed through reconciliation. And these types of changes can be that have an impact on federal spending. Another tweak they could make is allowing for subsidies for folks that do not have an affordable offer of family coverage through their employer. Currently, the premium tax credit eligibility is determined by reference to the cost of employee-only coverage, and that is, can be somewhat tough for people, that need the family coverage, and the employer is charging, a significant percentage of the cost for it. And so this would allow those folks to get premium tax credits. Another move that can be done through reconciliation. And we'll see if they are able to push something like this through. I could also see an expansion of Medicaid, in particular, a push to get the holdout states to adopt Medicaid expansion, like as envisioned under the original Affordable Care Act. There are about 10, maybe 12 states out there that haven't yet expanded Medicaid. That number is shrinking each year. There's federal matching funds to sweeten the deal a little bit. But if those states were all to expand Medicaid as envisioned under the ACA, it would be at least 10 million more people covered. It would go a long way toward the more universal coverage. It could dispense with some of the talk about single payer, because there's the vast majority of the country is not in need of a single payer system. They get their coverage through the employer-sponsored health plans. Other actions we could see from the Biden administration, one we saw already was offering a special enrollment period for marketplace coverage. It's a 3-month special enrollment running 3 months starting February 15th. Again, encouraging Medicaid expansion. These 3 states in particular have a lot of people who would benefit from Medicaid expansion. I think hopefully rather quickly, they will look to disallow the Medicaid work requirement waivers. These are things that the red states tend to seek from time to time. It's a requirement that people work in order to receive Medicaid. All this ever does is throw people off of Medicaid. It doesn't do anything to get more people employed. And so these are measures that Democrats you typically do not support at all, and will look to make quick work of. There is a review of all Trump administration regulations that hadn't yet hit the Federal Register, like the EEOC wellness regulations. I think they may also review some of the other Trump administration regulations, in particular the ones on short-term limited duration insurance and individual coverage HRAs. Those are all final regulations, and those plans are all up and running and continue to work fine. We don't see a big uptake in them normally in the employer-sponsored plan workspace. And I would hope the Biden administration really wouldn't want to kick people off of these plans. They seem to work well for people that have them. The STLDI plans are commonly referred to as mini med plans. They're short-term limited duration insurance. They tend to operate more on like an indemnity type of schedule, but certain groups of employees tend to like them. That brings me to the end, actually, of my prepared slides. It looks like I have a few minutes for questions.